has been the consulting editor of several Indian financial newspapers. His scholarly work is an inspiration for the youth and especially for students like us at Lokneeti. Mr. Debroy is well equipped in both Hindi and English. As a translator, he is best known for his magnificent rendition of the Mahabharata in 10 volumes, the consulting editor of several Indian financial newspapers. In 10 volumes, as well as the 3-volume Valmiki Ramayana, both of which have been published to wide acclaim by Penguin Classics. He's an award-winning professional and has received several awards, including honorary doctorates. In 2015, he was awarded the Padma Shri by the President of India. On behalf of Lokneeti, I would like to welcome Mr. Bibek Debroy and share with us his experiences that he's gained over the years. And now I'd like to hand over the floor to Mr. Debroy.
Thank you, Lokneeti, for inviting me. The internet connection is very, very unstable, so I'm warned. At any point in time, if you cannot hear me, I know you cannot see me. If you cannot hear me at any point in time, please try to let me know. Can you hear me right now? Can you hear me?
We can hear you, sir.
Okay.
But it's not very clear.
Yeah, there's echo.
Yes, I'm not very sure whether I can do anything about it or not, because as I said, the Wi-Fi is not very stable today, which is always a problem doing something from home on 26th. Happens to be a holiday. I'm particularly delighted that I can see my friend Subhashish Gangotpadhyay. I've been asked to talk about the constitution India should have, which is extremely because it's pertinent as well, because it happens to be Republic Day. We celebrated the 75th year of independence in 2021. And on 15th of August 2021, Azadi Ka Amrit Mahotsav was launched, which amongst other things sets the template for what we want India to be in 2047. When India became independent, soon after that, the Constituent Assembly adopted formally the Constitution on 26th of November 1949. On 26th of November 1949, adopted the Constitution, and that particular Constitution is the Constitution that entered into force on 26th of January. The Constitution sets the framework for the entire polity. It sets the framework for all policy decisions. The Constitution that we have today is not the Constitution that was adopted in 1950. If the Constitution was adopted in 1950, there have been more than 100 amendments. Indeed, in the course of the Constitution debate, Jawaharlal Nehru said that the Constitution is meant to be dynamic. It is meant to represent the will of the people. The Constitution, the Indian Constitution, therefore, has been described as a living constitution. It constantly evolves. I said that there have been more than 100 amendments in the Constitution entered into effect on 26th of January 1950. All of those amendments are not equally important. Here is my subjective and tentative list of the amendments since 1950 that I regard as particularly important. Amendment number one, it contained freedom of speech. It is Schedule 9 in the Constitution, and Schedule 9 inserted into the Constitution means that anything in Schedule 9 cannot be questioned in a court of law. The First Amendment also introduced Articles 31A and 31B, and Articles 31A and 31B impose curbs on the right to property. And I will come back to this point again later. The next amendment, which I regard as very important, was the Fourth Amendment. The Fourth Amendment was about Articles 31, 35, and 35. And again, what is important for us to remember is that this amendment also curbed property rights. The next amendment I regard as important is the seventh one, which reorganized the states along linguistic. Come now to amendment number 17, which introduced Article 31A, amended Article 31A, and was pertinent because it talked about the acquisition of assets. Again, impinging on property. The 24th Amendment told us that
Hello, sir.
Parliament
I'm sorry to
fundamental rights.
Mr. Debroy, I'm sorry to interrupt, but we are not able to hear at all. So, is it possible to just join from phone? आपकी आवाज बिल्कुल नहीं आ पा रही है इस तरफ.
Well, maybe what we can do, there seems to be only one option then, because the Wi-Fi connectivity is very, very bad. In which point were you able to hear me? The only alternative that I can think of is if someone rings me on my phone.
जी जी. So
on an audio mode.
अभी मैंने आपके ऑफिस से बात की है and they are trying to get a phone so that आप उस पे join कर पाए.
There is no point talking to my office because this happens to be a holiday. So the only option possible is for you to ring on my mobile, which you already have, and we'll continue this on the mobile.
जी जी.
Subhashish, while we're getting started, do you want to sort of engage with the class?
Well, we were going through a series of introductions,
Yes.
but I think he's back.
Okay,
If
right.
and if Vivek could start from the beginning, sorry Vivek, then that would be fantastic.
Yeah.
जी जी. So एक बार टेस्ट कर लेते हैं. अभी सर बोलेंगे, एक बार देखिए आप सुन पा रहे हैं कि नहीं. Yes
All
sir.
right.
जी सर. आप एक बार टेस्ट कर लेंगे सर कुछ बोल के.
Yes, can you hear me?
Perfect.
Perfect.
Great sir, you can go ahead sir.
Okay, so how far were you able to hear me? Shall we start from the beginning?
Beginning, please.
I
please,
mean,
please.
everybody's saying if you could start from the beginning.
All right, so let me start from the beginning again. I'm sorry
Thank
we
you.
have to do it like this, but unfortunately the Wi-Fi is very unstable today. So let me begin by thanking Lokneeti for having invited me to talk to you today. The topic that's been given to me is a topic of what kind of constitution India should have. This is, of course, a very relevant topic because today we are celebrating 26th January, which is our Republic Day. Last year, we celebrated the 75th year of independence. And on the occasion of the 75th year of independence, the Prime Minister, the government, announced the launch of Azadi Ka Amrit Mahotsav. Azadi Ka Amrit Mahotsav is going to set out the template for governance, the template for economic development that India should have in the year 2047. India became independent in 1947, so in 2047, we will celebrate 100 years of independence. What is much more pertinent for us is not the midnight hour in 1947, but the Constitution, because that is what we are talking about today. The Constituent Assembly, after going through several debates, formally adopted the Constitution on 26th of November 1949. Everyone knows that. That's a standard GK quiz. On 26th November 1949, the Constitution was formally adopted and it came into force on 26th of January 1950. So on 26th of January 1950, we got this Constitution, and this is a Constitution that determines the nature of the polity that India has today. It gives us the framework for the formulation of economic policies. To state the obvious, the Constitution that we have today is not the Constitution that was enacted on 26th of January 1950. There have been several amendments. To be precise, there have been more than 100 amendments since that Constitution was enacted in January 1950. In the course of the Constituent Assembly debates, Jawaharlal Nehru said that the Constitution is meant to be dynamic. The Constitution is meant to reflect the will of the people. Accordingly, as I said, the Constitution has been amended more than 100 times. All of these amendments are not equally important. In my subjective assessment, the amendments that have been extremely important are the following. I will read out the numbers of the amendments, but the numbers are not terribly important. What is more important is what these amendments did. The first amendment was the first amendment which curbed freedom of speech. It introduced a Schedule 9. Schedule 9 in the Constitution are laws that cannot be questioned in a court of law. And that First Amendment also curbed property rights. We next had the Fourth Amendment. The Fourth Amendment also curbed property rights. Next, we had the Seventh Amendment, and the Seventh Amendment reorganized states along linguistic lines. The 17th Amendment, which concerned the acquisition of estates, was also indirectly about curbing of property rights. We next had the 24th Amendment, and the 24th Amendment told us that Parliament, which in an indirect democracy like ours reflects the will of the people, can dilute fundamental rights. 25th Amendment, it restricted property rights again and curbed the rules for compensation in case of acquisition. 26th Amendment, abolition of privy purses. 29th, 34th, 40th, all of these combined to insert land reform laws in Schedule 9. And Schedule 9, remember, I said, consists of a list of laws that cannot be questioned in a court of law. Next, we have, of course, the famous 42nd Amendment. The 42nd Amendment not only introduced the notion of fundamental duties for citizens, it also changed the preamble to the Constitution and made the Constitution, the preamble to the Constitution, a socialist and secular one. I need to mention that in the course of the Constituent Assembly debates in 1948, there was a great deal of discussion about whether the word socialist, whether the word socialism should at all be inserted in the Constitution. And at that point, Dr. Ambedkar said that since we are enacting this Constitution also for posterity, why should we decide in advance what kind of socio-economic system future generations want? Why should we freeze them by insisting that a word like socialist or a word like socialism should be inserted in the Constitution? Be that as it may, the 42nd Amendment made the preamble a socialist republic. Next, we had the 52nd Amendment, which introduced the anti-defection law. We had the 61st, which reduced the voting age to 18. We had the 73rd and the 74th constitutional amendments, which introduced the notions of Panchayati Raj institutions and urban local bodies. The 76th Amendment brought reservations into the 9th schedule. The 86th Amendment introduced a right to education. The 91st Amendment restricted the size of the Council of Ministers to 15%. And of course, the 101st Amendment introduced GST. In everything that I've described so far, the individual numbers of the amendments are not important, but what I want you to note is 1, a progressive dilution of property rights. 2, notions of governance, economic governance, which I will come back to. 3, decentralization through PRIs and ULBs. And 4, of course, the introduction of the word socialism. The Constitution did not evolve out of thin air. Many people do not know that the Constitution, or large sections of the Constitution that we inherited in 1950, they were based on the Government of India Act of 1935. The Government of India Act of 1935, to state the obvious, was passed in a colonial era, and the Government of India 1935 was to a large extent based on the Government of India Act of 1990, a piece of legislation that is today more than 100 years old. So the obvious question to ask is, even if I do not get into the nitty-gritty of the amendments and the nitty-gritty of the Constitution, should a Constitution that base several of its principles on the basis of Government of India Acts of 1919 and 1935, should that have any relevance now in present-day India? To take an example of that, consider the 7th schedule. The 7th schedule lays down 3 different lists. There is a union list, there is a state list, and there is a concurrent list. Effectively, when we are talking about government, when we are talking about governance, we are talking about government delivering public goods and services. When I'm using the word public goods and services, when I'm using the expression public goods and services, I'm not using it only in the sense that an economist uses the term public goods and services, namely the coinage which was popularized by Paul Samuelson. I'm using the expression public goods and services in a more general sense, in the sense of goods and services that will not be delivered by the private sector, and therefore these are goods and services that have to be delivered by the government. There is always an optimum level of governance, there's always an optimum level of government at which these public goods and services are best delivered. I mentioned the states earlier. If I look at the states, I have states that have a population size that is around 600,000, 700,000, a state like Sikkim, and I have a state like Uttar Pradesh, which has a population size of something like 200 million. If I talk about geographical area, I have a state like Goa, and I have a state like Rajasthan. Clearly, from the point of view of delivering these public goods and services, we do not have an optimal level. Because below that optimal level, there are diseconomies of scale and scope. Above that optimal level, we also have diseconomies of scale and scope. And indeed, one would have expected that when the 7th schedule was formulated in 1948, there should have been legitimate questions asked about what is the basis for inserting one particular item in the union list, another item in the concurrent list, and a third item in what was then the provincial list, which of course now is the state list, provincial list as in the Government of India Act of 1935. But the chairman of that particular discussion was Dr. Rajendra Prasad, and Dr. Rajendra Prasad simply overruled any discussion. So far as the 7th schedule is concerned, and I'm citing the 7th schedule only as one particular example, clearly we need to think in terms of first principles. At what level are goods and services optimally delivered? Is it a population threshold of 25 million? Is it a geographical threshold of 25,000 square kilometers? Recently, there's an organization known as BIDI, and BIDI tried to examine the 7th schedule from the basis of first principles. And I'd recommend to everyone who's listening in or watching, I'd recommend to everyone that you should read what BIDI produced perhaps 1 year ago. I'm not suggesting that one necessarily has to agree with everything that BIDI suggested, but the point I'm making is that one should look at something like the 7th schedule on the basis of first principles. But the 7th schedule was only one example. I mentioned earlier the large number of amendments that we have had. If you look at the amendments, those amendments are roughly of two types. Chronologically, time-wise, they belong to two different time periods. One set of amendments were amendments that happened before 1973. Till the 29th Amendment, all amendments to the Constitution were pre-1973. Why am I focusing on the year 1973? I am focusing on the year 1973 because in 1973, we had the famous case, Kesavananda Bharati versus the state of Kerala. In the course of the Kesavananda Bharati versus state of Kerala, what evolved was what is known as the basic structure doctrine. The basic structure doctrine simply says that the basic structure of the Constitution cannot be altered. The basic structure of the Constitution cannot be modified. And today, we are stuck with the basic structure doctrine. Remember what I said about the Constitution earlier, about it being dynamic? That is the reason the famous constitutional historian Granville Austin referred to India's constitution as a dynamic constitution, as a living constitution. On this Keshavananda Bharati judgment and the basic structure doctrine, let me mention 5 different points. 5 different points in bulleted fashion. That Keshavananda Bharati judgment was decided by a bench consisting of 13 judges. So there were 13 judges who delivered the Keshavananda Bharati judgment. Everyone knows about the basic structure doctrine. Everyone knows probably about the Keshavananda Bharati judgment. What many people do not remember always is that there was a ratio in that particular judgment. And the judges decided 7:6. Let me repeat this. The judges decided 7:6, so it was not unanimous. The judgment that the basic structure of the Constitution cannot be changed was decided in a ratio of 7:6. In other words, if only one single judge had ruled the other way, we would have not had the basic structure doctrine. Because of the views of one particular judge in 1973, we are stuck with that basic structure doctrine, which says that the basic structure of the Constitution cannot be changed. The second bulleted point I want to make about the Keshavananda Bharati judgment was, as I mentioned earlier, there were amendments to the Constitution even before 1973. Some of them I mentioned, and several of them did alter the basic notion of the Constitution, the basic structure of the Constitution. But before 1973, nothing was ever mentioned about the basic structure doctrine. The issue cropped up in 1967. The issue cropped up in 1967 in a famous case, the Golaknath versus State of Punjab case. In 1967, the Supreme Court said nothing about the basic structure doctrine. So amendments before 1973, even if in common perception they are perceived to be substantial, were not amenable to the basic structure doctrine. The third bulleted point I want to mention is any court decision happens in a certain chronological context. And this was delivered in 1973, roughly the 1970s. Roughly the mid-1970s. This was the period of the emergency. The more important question, and again a bulleted point, is who is going to decide? Who has the right to decide whether the basic structure of the Constitution is being changed or not? Who will decide? Effectively, in 2 different cases, an Indira Gandhi versus Rajnarayan case in 1975 and the Minerva Mills versus Union of India case in 1980, the courts have said, the courts have told us that the courts will decide whether the basic structure of the Constitution has been altered or has not been altered. So it will be up to the courts to decide. Now notice, the Constitution is meant to be dynamic. Amendments to the Constitution are supposed to take place via Parliament. Parliament reflects in an indirect democracy like ours the will of the people. Even if the will of the people through Parliament requires an amendment to the Constitution to reflect altered circumstances, it is perfectly possible for courts to say that we will overrule this because the basic structure doctrine has been violated. In other words, because of the 1973 Keshavananda Bharati case, the constitution has been frozen. Do I have any problem apart from the philosophical problem of judges deciding when the basic structure doctrine is violated or not? I do. The additional problem I have is this is extremely subjective. And remember, I mentioned earlier that 13-judge judgment where the ratio was 7:6. I will refer you to a rather interesting study on a completely different matter that was undertaken by the Center on Death Penalty by National Law University, Delhi. Center on Death Penalty, National Law University, Delhi. In 2017, they did a very interesting study. You will find it on their website. What was this study? All of us knew that the death penalty is imposed in the rarest of rarest cases. The death penalty is imposed in the rarest of rarest cases. In this interesting study that was done by National Law University, Delhi, the Law University devised 3 hypothetical cases. These were 3 hypothetical cases. 3 hypothetical criminal cases. And these cases were circulated to 60 former Supreme Court judges. 60 former Supreme Court judges who of course knew that these 3 hypothetical cases were hypothetical cases, and these 60 former Supreme Court judges, out of these 60 former Supreme Court judges, 47 in the course of their careers had imposed the death penalty in some cases. So these 60 former Supreme Court judges were asked, in these 3 hypothetical cases, will you or will you not administer the death penalty? Do these cases represent rarest of rare? Do they represent rarest of rare, or do they not represent rarest of rare? What is illuminating about this study is these Supreme Court judges, several of whom, most of whom had administered the death penalty, could not agree on whether these were rarest of rarest cases or not. So they themselves differed. Their assessments of what was rarest of rare, their assessments of what deserved the death penalty and did not deserve the death penalty was also extremely subjective. Extrapolating that as a metaphor, if the court is asked, if judges are asked whether an amendment to the Constitution reflects a change in the basic structure or not, by the same logic, that is also likely to be extremely subjective. So other than the philosophical problem, and my philosophical problem, as I stated earlier, is the Constitution should be amenable to amendments through Parliament because that reflects the will of the people. That's the philosophical problem. The second problem, which I now have just underlined, is in addition to the philosophical problem, I have a problem because the assessment about whether there is a change in the basic structure or not is extremely subjective, and as the example I just gave illustrates, judges will not necessarily agree. Everyone talks about reforms. And constantly the government will be criticized, the government is introducing reforms, the government is not introducing reforms. All of us have our own individual prisms with which we evaluate whether reforms are being introduced or are not being introduced. Whichever way you define reforms, reforms are about competition, reforms are about choice, reforms are about efficiency, and reforms are about markets. Anything that stands for competition, choice, and efficiency, anything that moves towards a market-determined mechanism is reform. Anything that retreats is not reform. What is a market? A market is not an agricultural market. It's not a mandi where buyers and sellers gather together. Markets are conceptual structures, they're notional structures used by economists, where notionally buyers and sellers come together. Every market functions in a certain social context. Every market functions in a certain institutional context. Every market functions on the basis of an institutional mechanism, which is in this particular case set by the Constitution, which provides the framework for all the laws that we have in India today, all the policies that we have in India today. Markets require property rights. As I gave examples earlier to suggest that property rights which existed in the Constitution in 1950 have been progressively diluted, and today property rights, or the right to property, is no longer a fundamental right. If the right to property is no longer a fundamental right, then how can we, given the present Constitution, have a market-driven society? I mentioned the preamble to the Constitution. I mentioned the 42nd Amendment, which changed the preamble to make India a socialist republic. Most of you probably know that following this, the Representation of the People Act of 1951 was also changed. As a result of which, no political party can be registered in India unless it professes to be a socialist party. What's wrong with this? Nothing wrong with this, except that I do not understand what the word socialism means. Perhaps this is also an issue that the courts will have to decide on, what is socialist and what is not. And I want to quickly mention a 1978 case, which was Excelware versus Union of India. And in that particular case, the court ruled that nationalization is socialism. By that token, the moment we do not have nationalization, we are retreating from socialism, so it is against the basic structure of the Constitution. Article 39C says that it is the business of the state to ensure that there isn't unnecessary concentration, not only of wealth, but of the means of production. So if the state does not intervene in preventing concentration of the means of production, of course, is an expression that is what used to be particularly popular in the context of the centrally planned economies, then the state is deviating from its duty as laid down by the Constitution. And there is, of course, a definition of the state in Article 12, which covers almost everything. In the year 2000, there was a National Commission to review the working of the Constitution, chaired by Justice Venkatchelaya. And the report of that particular commission, the National Commission to Review the Working of the Constitution, which was submitted in 2 volumes in 2002, is particularly relevant given the topic that we are talking about. But I will stick my neck out and say that National Commission to Review the Working of the Constitution only tinkered. It did not look at the Constitution on the basis of first principles, a few of which I indicated earlier. A more substantive issue is about the directive principles of state policy. I will come back to some details of where I think we need to look at the Constitution in detail later on, a little later in the course of my talk. But there are several other issues that I want to flag right now. One of the issues I want to flag is in the Constitution we are told that there is going to be a Rajya Sabha. What is the Rajya Sabha? When the Rajya Sabha was originally proposed, it was meant to reflect the interests of the states or provinces originally. Ask yourself the following question. Let us look at the kind of questions that are raised in Rajya Sabha. Do those questions reflect the interests of the states? The answer is by and large they don't. The answer is after the domicile requirement was abolished in the year 2003, Rajya Sabha has only become a second chamber. There was a court judgment, Kuldeep Nair versus Union of India in 2006, when the court ruled that the Rajya Sabha was just a second chamber. Some of you are aware that in many states, in addition to assemblies, we used to have the counterpart of the Rajya Sabha, and those were the legislative councils. Many states have abolished the legislative councils with no great harm done. I am citing the Rajya Sabha again as one example. Shouldn't we today ask, what is the relevance of the Rajya Sabha? Why do we have the Rajya Sabha? Let me now come to the question of Parliament in general. And let me flag the question of Parliament's productivity. Parliament's productivity has been measured, or one has attempted to measure it, through several exercises done by PRS. Most of you are familiar with PRS. Should we not ask questions about Parliament's productivity? And Parliament is very much part of the Constitution. Let me also flag the issue of simultaneous elections. And the reason I'm mentioning simultaneous elections is cast your mind back to the 1950s. And it is important to cast your mind back to the 1950s because in the 1950s, there were several things that were synchronized. The first 5-year plan was for the period 51 to 56. The first Finance Commission was for 1951, was in 1951. Elections to Parliament, elections to state governments were synchronized. Over a period of time, because of various reasons, this synchronicity broke down. The breaking down of this synchronization meant that governance issues, delivery of public goods and services, which I mentioned, became exceedingly difficult. Amongst other things, the Model Code of Conduct. I mentioned simultaneous elections, but don't misunderstand. Simultaneous elections is a messy business. But I will flag the 79th report of Rajya Sabha's committee, which mentioned the Model Code of Conduct and told us how the Model Code of Conduct in the context of repeated elections at the union government level and at the state government level derails many public expenditure programs. As yet another example, let me mention the criminalization of politics or the politicization of criminals, documented by something like ADR. Let me mention a point that I mentioned earlier, which is about the delivery of goods and services and an optimal level at which one should deliver these goods and services. We have today 28 states and 9 union territories because Jammu and Kashmir is in a slightly different category now. And these states and union territories reflect a great deal of heterogeneity. India, strictly speaking, is not a federation in a legal sense. It is not a federation in a legal sense because under Articles 2 and 3, the union government can form as many states as it wants. So legally speaking, it's not a federation, although loosely we use the word federation. I mentioned earlier that the states have been formed along linguistic lines. There was a State Reorganization Commission in 1953, and that State Reorganization Commission said that apart from various other considerations, we should look, it did not exactly use this expression, but it did say we should look at the economic delivery of goods and services, of public goods and services as a determinant of how and where we should form states. And let me mention the third tier of governance, the Panchayati Raj and the urban local bodies, which is where most public goods and services are actually delivered. We constantly talk about union to state relationships, decentralization and devolution of decision making there. Rarely do we talk about decentralization and devolution of decision making within states. We constantly talk about the Union Finance Commission. Rarely do we talk about state finance commissions. There are three organs of state that are mentioned in the Constitution. These are the executive, the judiciary, and the legislature. If one is talking about revamping the Constitution, if one is asking a question about what kind of Constitution should we have, we should look at the efficient functioning of all three. I have mentioned little bits and pieces about the legislature. The executive is obvious, but we should also ask similar questions about the judiciary, where we have a large number of cases that are pending in courts, but rarely do we as citizens ask questions about the judiciary. Let me now come to the concluding part of my talk, which is about which particular sections of the Constitution should we look at in terms of deciding what kind of Constitution we should have. What kind of Constitution should we have, given our objective of ensuring that India has a better template of governance? What kind of Constitution should we have? If we ask that question from first principles, what kind of Constitution should we have if we dealing that historical and colonial legacy of the Government of India Act of 1935 and the Government of India Act of 1919? I will now proceed to list out which are the major sections of the Constitution which I think we should take a look at. In fact, I think an organization like Lokneeti should actually do a report on what kind of Constitution we should have. So here is my list of which are the various articles of the Constitution, which are the various elements of the Constitution that one should look at. And obviously, this is a somewhat subjective list. First, we should look at the preamble. The preamble is not really enforceable. Nothing is enforceable in a court of law, but the preamble sets the tone for everything. So I think we should take a look at the preamble and we should try and answer, because much of the churn that we are witnessing in India today, I think, is a reinterpretation of what we mean by the word socialism, what we mean by the word secularism, and indeed what we mean by the word democracy. So we should certainly look at the preamble. We need to look at Articles 5 and 6, and Articles 5 and 6 are on citizenship and what it means to be a citizen of India. There are clauses in Articles 5 and 6 which reflect historical conditions, pre-partition conditions. Do we need those? In what form? The next bunch of articles we should look at are in the segment of fundamental rights. In the segment of fundamental rights, under the head of fundamental rights, we should look at Articles 15 and 16, which set the basis for affirmative action. We should look at Article 19, and remember what I said earlier, it removed right to property as a fundamental right. We should look at Article 21, which is about right to life, and we should look at it because Article 21 on right to life has increasingly been interpreted in a very, very broad sense. The next head, the next head we should look at is the head of directive principles of state policy. Under directive principles of state policy, which are Articles 36 to 41, we should, for instance, look at something like prohibition, Article 47. Does that make any sense? We should look at the Uniform Civil Code, 44. We should look at sections like Article 43 and 43A, which says that the state, defined as the government, must ensure workers' participation in management, must ensure the development of cottage industries. Given the altered scenario, is that the responsibility of the state? So we need to look at the entire statement on directive principles of state policy. The next head we need to look at is the head of union. The head that is called union government, the functioning of union government in the Constitution. Article 80 on the Rajya Sabha. We need to look at the Supreme Court. We need to look at the role of the CAG. The next segment we need to look at is a very extremely important segment from the point of view of delivery, economic delivery of goods and service, public goods and services, which is Article 243. Article 243 on panchayats, urban local bodies, and even cooperative societies. It is my personal belief that if a certain geographical segment continues to be marginalized, it will never be mainstreamed. It will perpetually remain backward and deprived. We need to prevent geographically the creation of enclaves. And I'm stepping into a slightly controversial area now. I'm talking about the head of scheduled and tribal areas, and Article 244, which ensures that these never get mainstreamed. A large segment increasingly is the distribution of legislative powers between unions and states and relationships between union and states, something that I alluded to when I spoke about the 7th schedule. So I'm talking about Articles 245 to 255. I'm talking about Article 256, which is on precedence rule. I'm talking about Article 262 on water disputes, and most importantly of all, perhaps, I'm talking about Article 263, which is on coordination between states. I now come to the parts of the Constitution that are called 11, 12, and 13. These are the bunch of articles that are from 264 to 307, and I don't have enough time to go into the details. I also want to flag what goes by the name of services. The All India Services, for example, a bunch of articles from 308 to 323, particularly 310 to 311, which concern tenure and removal of people in the All India Services. And of course, the tribunals. Elections, I alluded to simultaneous elections as one instance of that, Articles 324 to 329. Emergency provisions, I mentioned that earlier, 350 to 366. And perhaps, given the thrust of my talk, Article 368 on amendments to the Constitution and how those amendments to the Constitution should be brought about. As I said, the intention of this talk is not meant to suggest, is not meant to provide for you a 2-volume report on what the new Constitution should be. But hopefully in the course of this talk, which was constrained by problems of net connectivity, I've been able to explain to you why we need to take a relook at the Constitution that we have today, why, and I've also indicated some of the lines along which we need to review the Constitution from my subjective point of view. Thank you very, very much.
Thank you, Dr. Debroy. Jasmine, in interest of time, as Mr. Debroy has to leave sharp at 12:30, can I invite you to give the vote of thanks? I'm leaving the questions, Mr. Debroy. I would request that you could come back again when at time when internet is working, and I'm sure there are a lot of questions.
No, questions are for Lokneeti to answer. Questions are for Subhashis Gangopadhyay to answer. He should do this study.
So, yeah, Jasmine, over to you.
पहले मैं डॉक्टर am I audible? Am I audible, ma'am? Yeah. सबसे पहले मैं आप अपने सहपाठियों की ओर से श्री विवेक देब्रॉय जी को उनके समय के लिए शुक्रिया अदा कहना चाहती हूँ. As we all know कि time is the most expensive exchange, And as a student of policy, it's been an honor to be in the presence of an individual who is shaping the future of this nation through his policy actions. I am Jasmine Kaur, and I am a student of Lokneeti at ISPP. For me, this session has been a very insightful one. I can say the same for my cohort. The highlights for me have been regarding, sir has talked about a lot about the fact that this constitution is a dynamic one, and the founders of the constitution had a similar view, that that is why Jawaharlal Nehru also said that we are not picking up some certain facets for the constitution. We want that it should evolve as the society evolves, and that's exactly Bibek Debroy has highlighted on that. Because of the basic structure, it has been frozen in some sense. So that is one highlight which has been for me, that as a policymaker, we have to make sure that the constitution keeps evolving as the needs of the society keeps evolving. Secondly, he highlighted about the judgment, the Keshav Bharati judgment, and he talked about how one man made a difference in the entire judgment. That also states something about what, as a policymaker, we can do to make difference in the policies and the laws of the nation. There were highlights about decentralization. The how the states should further focus upon decentralizing their powers to the local governments. We should, I think, as a cohort, we should further discuss upon how that can be done. Then, apart from that, he highlighted upon how judiciary should be a party to bringing reforms rather than trying to prevent it from happening. So we should focus. The focus should be upon how executive, legislature, and judiciary can work as in cohesion. So these were some major points that I take from this session, and we would like to discuss that further. Thank you, sir, again for your time. It's been a great start to the program. The students who want to discuss further can stay back.
SG, would you like to say something? A big round of applause to Shri Bibek.
Thank you.
Yeah.
Thank you.
SG, would you like to say?
It's always a pleasure to listen to Dr. Debroy. I have known him for many, many years. He has also taught me for a few months when I was a student. But my friendship with him is not because he was a teacher. It's not because I met him at college, not because he's an economist, but because he's one of the most incisive minds that I have come across. So I'm extremely, extremely grateful to Bibek Dutt for having spent his time with us, especially in this very, very, I think, unique endeavor that ISPP has embarked on, which is to democratize public policy so that every citizen participates in it. And what Bibek Dutt's main message is precisely that, right? That how would all of you, the next generation at least, correct the things that we have been unable to correct. So thank you very much, Bibek Dutt. I do hope that you will continue to support ISPP and Lokneeti in the way you have done so far. And I do want to engage you more often. We will squeeze out time. We will squeeze out time.
Always welcome.
Thank you. Thank you, Bibek.
Thank you, sir. Thank you.
All right, bye.
So great talk. I think we have a lot of thoughts now. We'll take it, post lunch when we meet informally to discuss. So over to you, Dhruva.
Right. So what we'll do then is perhaps we'll keep the Zoom session active for those who want to stay back and discuss. But otherwise, we'll meet everybody again at 2 o'clock. लिंक मैं एक बार चैट पे शेयर कर रहा हूँ. आपके कैलेंडर पे भी, अगर आपने गूगल कैलेंडर एक्सेस किया है, वो लिंक आपके वहां पे भी विजिबल होगा. वो लिंक आप 2 बजे ज्वाइन कीजिए. We'll discuss the program का rules and regulations, introduce you to the program, or give you an orientation about the various softwares that you'll be using. So look forward to seeing you at 2 o'clock, and those who want to stay back can stay back. And we can stop the recording and the broadcast also then.
Thank you, Louis.
Thank you. Welcome, everybody.
Thank you, SG. Thank you, Louis. I see